you think you have a lawsuit. Now you're looking for an attorney. You've gone through all these measures to find one that you think is the best fit for you. You contact them and arrange for a consultation. Then you meet with the attorney, either virtually or in person, and you start talking about your claims. At the end of the meeting, you go home and you're thinking, great, you found the right attorney for you. But unexpectedly, the next communication you receive from that law firm is that they're not taking your case. Why? Clock in, because I'm going to quickly give you the 11 reasons, the 11 factors that some attorneys, most attorneys, take into consideration as to why they decide to not take your case. Welcome to the employment space. This channel is designed to bring you a 360-degree view of the workplace directly from an employment attorney. Let's get into today's content. Number one is there's a conflict of interest. Upon meeting you, one of the primary things that an attorney must assess is whether there's a conflict of interest. And that's not really about your claims. It's about who are you suing, who's on or who's on the other side of the case. Even if you're on the defense side or the respondent side, whoever's on the plaintiff's or complainant side, an attorney must consider that as well. If there is a conflict of interest, meaning that maybe that attorney or the attorney's firm or the attorney's colleague, they've previously represented the person or the people or the entity on the other side, or someone that they know, or they know their family members, or there's some personal relationship outside of acting as an attorney. So for that reason, the attorney will reject your case because it seemed to be that there is a conflict of interest. Number two, you're not a good fit. Yeah, that's very important for an attorney because as attorneys, we are spending so much time. We're almost trading places. We are trained to basically take on your life when we take on your claims. So when we're kind of assessing the claims, we're also trying to see, honestly, energetically or vibrationally, if we're a good fit. Will we work well together? Do we think that this is really going to be a good match as we work through your claims? And if not, then the attorney will decide on that basis not to take your case. Number three is, are there any credibility issues? Again, one reason for the consultation is to listen to your side of the story and what types of claims you have, or what is your grievance. But we also need to assess other aspects of who you are. And if there are some credibility issues, something that the other side can use against you to bring doubt as to whether or not you're being truthful, then that is advantageous for the other side, but very bad for your attorney. So attorneys look for clients, not that you have to be perfect, but that there are not going to be any credibility issues that can work to your detriment and basically against your claims. Number four, we're also assessing whether there are any good defenses. Any good attorney during the intake consultation process where you're talking about your claims, there should be questions about, well, what do you think they would say? What do you think the company will say? What do you think the other side will say? What did they tell you? What did they show you? What did they give you? Depending on your claims, right? That's the questions will be fashioned after that. And if it seems like the other side has a slam dunk defense, then it would be a waste of your time and your attorney's time to take on the case. And for that reason, the attorney will listen to his or her gut instinct and not take on your matter. Number five is, are there any ethical reasons that the attorney assesses that would prevent them from taking on your matter? For example, I have a mentor that when I was a young attorney, he would say that there are certain cases he just would not take on as a criminal defense attorney. If there were any crimes against a child, he was just out of it. He just could not take it. And typically, that's one of the assessments, a major factor in different areas of the law. But overall, if an attorney thinks that there's some sort of ethical reason that goes against their morality, against our morality as attorneys, then we don't have to take on your matter. Number six, the attorney has maybe taken out some time to see if they can settle or resolve your matter very early, but if they do not have enough time for your matter, then they have an obligation to tell you that so you can move on and look for another attorney. Number seven. Now I'm going to hold your hand for this one, but I'm also going to tell you the truth. And number 7 is you can't afford it or you're not able to pay for the legal services. And I know that there are a great deal of attorneys out there in areas of law where there's something called a contingency basis, but attorneys are not expected to work for free. You don't like working for free? We don't like working for free. Okay, we can do public service if we want to work for free. No shade, but we're not obligated to take on contingency cases. That sometimes, depending on what's expected or what your case calls for, there needs to be some level of compensation up front, and you may determine as a prospective client that you cannot afford the legal services at this time, unfortunately. So as a result, the attorney will not take on your case. Number 8 is key, and that is you don't have any damages. You have a great experience when you're telling your story. The prospective attorney is like, these are some great claims. You're meeting all of the elements of the law. In other words, what you would need to prove that there is a grievance, except for the fact that you have the grievance, but you haven't suffered anything. A great deal of the laws will have a requirement that there are some damages, which means you've suffered based on how damages are defined by that law. So it doesn't mean that you haven't been upset or or inconvenienced, but if you do not have damages as defined by the law, then you don't have a complete claim equation, if you will. Okay, so you have, you have a great grievance, you have a great story. It's been unfortunate that you had to go through these experiences, but you don't have any damages, so the attorney won't take your case. Number 9 is that the prospective attorney, based on the conversation or interactions that the two of you have had, is able to determine, or it's been suspected that you're not able to withstand the legal proceedings, the actual process. And that can be a federal court case, that can be a state court case, that can be a federal agency process, it can be mediation or arbitration. And these things are taxing. These proceedings are absolutely taxing on your being, on your well-being. And sometimes they're not resolved very quickly. So you have to have the stamina, the mental strength, the fortitude to get through the process. It's not just your attorney taking on the matter, but there are a lot of parts of the proceedings that you're going to be a part of, and it may be determined based on the interactions that you can't stand the rain. Number 10, there seem to be inconsistencies in your story. So during the intake process or when you're meeting for a consultation with an attorney, we're asking questions to see what you're sharing with us, but also how consistent are your stories. And eventually they'll fall apart. So even if you say in the beginning something that seems consistent, eventually the inconsistencies will come out. And it's the attorney's job to figure that out very soon, because no one wants to waste their time. And number 11, are you likable? So you may have great claims, you may be consistent, you may have damages, you may be in the position to pay, and more pay. But there's something about you to the attorney that communicates that maybe the prospective attorney likes you as a person, right? Thinks you're cool, but there's a certain way that a jury needs to see you. Right? You being a likable person can be a threat to opposing counsel, because opposing counsel doesn't want you to be likable to a jury, right? But your attorney must see you as a very likable person, because that's going to potentially translate, or at least increase that the jury will attach to your story and to you a certain way. Okay, I'm going to end here. There are plenty of other reasons why an attorney may reject your case. If you're an attorney, you're watching this, feel free to add that information to the comments below. Remember to like, share, subscribe, and comment below and share. And I'm going to go ahead and clock out. I'll see you next time.